I'm going to say hello to everybody who is signed in. We may have some stragglers who sign in. Thank you for your patience, especially those who signed in early because you've been waiting a while just watching us on our screens here. Anybody who is signed in cannot see each other. We can't see you, but you can see the presenters who are here today. And I'm just going to say, welcome to the Family Law Committee's annual update program. Obviously, we're coming to you remotely this year and not live and in person as we normally do. Our presenters today are the Honorable Ruth Ann Jacobowski, who is our Family Division lead judge, who is going to speak about the status of the court reopening policies, and which is itself a work in progress. So she is going to do the best she can to describe where we are right now, where we are going, and then also to field questions. We also have Eileen Glickman, who is going to talk about a legislative update. Eileen is not only one of our own members, but she is also the co-chair of the Legislative Committee for Family Law and the Juvenile Law Section Council. Did I get that right, Eileen? I think? Yes, that's okay.
Yes, Family and Juvenile Law Section Council.
Thank you, thank you. And then, of course, Richard Jacobs, who has been doing the case law update for how many years now, Richard?
It's about 15.
15 years, yeah. So you are the one who has been kind of the steady constant through this. Everybody should have gotten handouts from Rachel Rocco's office via email. So if you haven't, we can get them to you. But if you check your email, you should have two handouts, one from Richard Jacobs with his case law update, and then another from Eileen Glickman with the legislative update. I'm going to throw it to our committee chair, Elena Story, who was responsible for getting this put together. And I really do appreciate the fact that you kept us organized and trying to get at least one program in before your tenure ended. I'm going to throw it over to you if you would like to address any comments to anybody.
Sure, I'll be very brief so we can get started. I just wanted to thank everyone for attending today and also giving me the opportunity to be your Family Law Committee Chair for this past bar year. We had a really busy and a really great year, of course, leading up to the shutdown. I was actually on maternity leave starting in February, and I want to thank my Vice Chair, Wendy Meadows, for not only being a great Vice Chair all year, but then pinch hitting for me while I was out on maternity leave. And then, of course, the missed programs that we had, hopefully we can make them up next bar year. And I'm very happy that we were able to come together for this final program to round out our bar year. And hopefully the happy hour we usually have after this, we can reschedule for another time and be together and see each other and catch up. But I look forward to next bar year with Wendy chairing the committee and also having Chris Malenga as the vice chair. And with that, I think we can go ahead and get started. And Bill, did you want to just mention about the chat as well? You want to take care of that? Here we go.
Yes. So what we're going to do is we're going to present this in segments so that Richard's going to go first with the case law for about 10, 15 minutes, and then we're going to do about a 5-minute Q&A after that. Then Eileen's going to go with the legislative update. We'll do a little Q&A after that, and then Judge Jacobowski will bring up the end of the program and again present us with information, and then we're going to be looking at a chat. You all have a little chat window at the bottom of your screen, all the attendees. So if you have any questions, please send them in. Elena and I are going to be looking at them, and then we're going to pose those questions at the end of the segment. So without any further ado, Richard, I'm going to turn things over to you.
Okay, thank you. This is certainly the first time in 15 years I've done this from my dining room table. So the first case that we're going to talk about is the Watkins case, which derives from an orphans court decision that went to the Court of Special Appeals, but it has ramifications in family law and certainly to take into consideration if you're drafting prenuptial agreements or postnuptial agreements. Mr. Watkins was what we would call a member of the Lucky Jeans Club, and his normal laborers were going to check his racehorses and the apartment buildings that his family owned. And he had been married for a considerable period of time. And I suspected this case may eventually become a Lifetime movie. Sort of the setting is Bloomingdale's. His wife becomes terminally ill, and he takes her to Bloomingdale's to the cosmetic counter to make her feel better. And there he meets Emmeline Wilson, who's 24 years younger than he is. And Ms. Wilson certainly was concerned about Ms. Watkins and her health, and sold her some cosmetics. Ms. Watkins died a short time later. During the last months of her life, Mr. Watkins starts seeing Miss Wilson for lunch, and about a week after his wife's death, they started dating, and a short time later went to West Virginia to get married. That wedding didn't take place, but a short time later, they did a second try and did get married in Florida. And as soon as they got married, she started writing large checks out of his accounts. And although his eyesight got bad and his health was deteriorating, Mr. Watkins somehow bought a $100,000 Audi, and then a short time later bought a $150,000 Mercedes, although he couldn't drive. And near the end of the marriage, or near the end of his, prior to his death, his children started trying to check up on him in Florida, and she had isolated him from the family. He eventually reconciled with his family and told his children that she had tortured him and had sat on him and beat on him. She became a frequent user at that time of the ATM machine and was taking out the maximum she could prior to his death. When he died without a will and without any type of agreement, she claimed her statutory 1/3 share. The trial court, the Orphans Court, and then subsequently the Court of Special Appeals found that she had unclean hands and denied her anything of his estate. So had there been a prenuptial agreement, that might have been avoided, or she might have gotten something. So the second case was a SENA case, and it was a child neglect. It's really a tragic case. It's Junick versus St. Mary's County Department of Social Services. And this case was every parent's nightmare. It was a typical two-parent working family, and father's job was to drop off the two young children in the morning, one to preschool and one to daycare. Then he would go to work, and wife would pick up the children after school. When she went to daycare in the afternoon, the daycare advised that the baby had never been delivered. Father discovered that he had forgotten the child and left the child in the car all day in the car, and he ran out to the car when he was notified. They couldn't resuscitate the child. The administrative law judge found that the lack of intent, because there was clearly no intent to injure the child, but it was no excuse for neglect, so he was found guilty of neglect. Next case is David A. versus Karen S. And it's involving attorney's fees, and it simply stands for extending in a same-sex marriage case if that involves a child, the non-biological parent has a right when there's custody, support, or visitation involved, and there's a child of the parties, the non-biological parent can make a claim for attorney's fees. Next case is alimony, and involves unconscionable disparity, KB versus DB. And I apologize in advance to Judge Jakubowski, but my experience has been that sometimes there are judges you can, when you read the opinion, knew they didn't like one of the parties. And when you read this decision, it's pretty clear the judge did not like the wife. The facts of the case were that they'd been married for at least 17 years at the time of the marriage. Husband made between $1.5 and $2 million per year. The wife had been out of the workforce the entire marriage. Court felt that she was capable of earning about $35,000 a year, which amounted to less than 2% of the husband's income. The trial court awarded her $12,000 a month for 30 months of rehabilitative alimony, and that was it. And found that the wife was responsible for the estrangement of the parties. And if you remember, the old Friedenberg case talks about that fault is a factor when you go through the alimony statute. The Court of Special Appeals reversed and said that given the length of the marriage, the disparity in their incomes, and the likelihood of the wife not becoming self-supporting, that this was a case for indefinite alimony. So the court sent it back. They made mention that the trial court, for some reason, looked at the standard of living, their lifestyles at the time of the marriage, not during the marriage, but at the time of the marriage. And the Court of Special Appeals said that that was not a relevant factor, that you needed to give more weight to the present standard of living. Although the husband's business had a substantial value, expert testimony showed it had not increased in value during the marriage, so she did not get any value of his business, but there were some issues about cash in the business. So when it was reversed, it was also sent back for to look at the cash issues. The next case involves a monetary award. It's Lasco v. Lasco, and it involves relief requested in pleadings. In the original complaint, husband filed for a limited divorce, asked for custody, child support, and other relief. Wife filed an answer as well as a counter complaint for limited divorce, alimony, and asked for custody. Husband subsequently filed a supplemental amended complaint asking for an absolute divorce, custody, child support, and other relief. Wife never filed an answer to that. The trial court at the marriage trial awarded wife a $35,000 monetary award. Husband argued that wife should not have been entitled to it because she never specifically pled that the court said that the pleadings as they had been filed were sufficient to support a monetary award. The next case is also an interesting case, involves civil procedure, Halstead v. Halstead. And this involved two lawyers who were getting divorced who reside in Carroll County. And the facts were that they were married in 1991 in Baltimore City. But they lived most of their marriage and had their children in Carroll County. On January 31st, 2019, the wife filed pro se her own complaint for divorce that had 717 numbered paragraphs. So you know the court loved that. In there, she asked for an annulment, an absolute divorce, and also alleged wrongful taking and or conversion. The husband was served in Carroll County and through counsel filed an answer stating, and it actually was a motion to dismiss for improper venue or in the alternative to transfer the case. The wife's position was that under the annulment statute that Baltimore City, because that's where the marriage was performed, was proper venue. The judge and no hearing was requested. The court, after reviewing the pleadings, simply dismissed the case, didn't even transfer it, and said that Carroll County was the only venue that was proper to adjudicate all three issues that she had pled. The next case is a case that we probably don't have any It won't involve any of us in Baltimore County because it involves smaller jurisdictions. And it involves electronic filing. Burnett versus Burnett involves lawyers' mailboxes in the courthouse. We haven't had lawyers' mailboxes in the courthouse in Baltimore County for many years. There had been a magistrate's hearing in Talbot County, and the magistrate did not render her decision at the time of the hearing. She subsequently rendered her written opinion and stuck it in the attorney's mailboxes. And on the last day to file exceptions, the lawyer went to his mailbox and saw the opinion, and he, the next day, the day after exceptions, or the day he filed to extend the period to file exceptions, but also asked for, filed a motion, alter, amend. The court denied the relief. Court of Special Appeals reversed and said it was an undeveloped record. And they said, given the MDEC requirements in the counties, that they had to determine whether or not the clerk's office complied with MDEC requirements in sticking the opinion in his mailbox. So it was sent back for further testimony. The next two cases involve retirement. First, and there's distinction in the two cases. One is Allred versus Allred. In that case, there had been a settlement agreement. And in there, the wife specifically was to receive a sum certain plus investment experience from a date certain to the date of the judgment of divorce. The trial court went beyond that and gave her investment experience after that period of time until the time of transfer, which was reversed and sent back and said the agreement contractually said what she was supposed to get, and so she was not entitled to that. Distinguishing that, Salkini versus Salkini, there was an actual trial, and the wife was awarded 50% by way of a quadro, and he used the value of the retirement as of the date of the divorce, and the court had authority toward investment experience from that date until the date of transfer. Next cases are involving custody and visitation. Gizzo versus Gertman. The court simply stated on appeal, the trial court must give special consideration to evidence that one of the parties previously committed abuse or neglect. It was not mentioned in the trial court's opinion, so it was reversed and sent back. In Azonia versus Solomon, it was another case where the judge obviously did not like the mother in the case because the opinion centered around there being a alcohol-infused party that both parents were at, but the child was not at. The court only makes a reference to the wife or the mother being at the party, and the court said that should not have been a factor, and after reviewing everything, sent it back with instructions that mother was to have custody. The last case involves religious agreements, and it's Nori versus Datsar, and it was a case of first impression in Maryland. The question presented was, may a civil court adjudicating a divorce enforce a provision in a religious marriage contract that required one spouse to make a payment to the other? And the Court of Special Appeals held that the court may enforce such a provision, but only if under secular legal principles, the contract satisfies the requirements of an agreement entered into by the party seeking to enforce the agreement. And it talked about the burden of proof and the confidential relationship. So it was sent back for further testimony. So that is it for the year.
A lot of cases, actually.
Yes.
All attendees, we are monitoring the little chat box for any kinds of questions. So if you have any questions for Richard, please just tap your chat at the bottom of your screen, and typed in the question and we'll see it pop up and we can then read it to Richard. I am curious, Richard, as to why Salkini was even a case. Why did the court need to even state that? It seems like it's a pretty clear proposition with investment experience.
That's what I felt when I read it. As soon as you read it, you wonder why it was there and then wonder why it was reported. But that was it. This was an unusual year that we had this many reported cases, because the last few years there have only been a couple each year. There are loads. And one of the things that we changed in the program years ago, we used to do interesting unreported decisions, but we stopped doing it because people would cite them. Obviously nobody has any interest in those.
Question actually did just pop up. What is investment experience? So can we explain that basic concept?
Sure. When the court, when a value is determined on whatever the value is, the market may go up or it may go down. So that when they talk about investment experience, that's a practice pointer for drafting also. Should make sure that you use the terminology investment experience, because some people used to put just the gains. Sometimes there are no gains, and it just depends on the time. So it's market activity. The market goes up, you share in the increase. If it goes down, you share in the decrease.
Richard, there's another question on the chat window about the Gizzo case, and asking, is it that the court has to consider abuse against a party or the children, or
Both.
Okay, Elena, I don't see any other questions. If any come up, Richard, we'll certainly send them your way.
I'm here.
All right, excellent.
Actually,
Thank you.
One other question real quick, I'm sorry. In the Lasco case where it said that the pleadings were sufficient to grant a monetary award on White's complaint for limited divorce, isn't there a case, I'm blanking on the name, where someone had asked for relief from a retirement account but didn't plead it and it was denied? I believe that had been upheld. Is that different in any way, or did they explain why she was entitled to the monetary award?
It didn't say. In this case was a real stretch, because they said that the husband was on notice during the trial because of discovery that marital property was at issue. So they addressed it that way.
Okay, thank you.
Richard, thank you so much. These materials are always invaluable. We always appreciate your hard work. There were a lot of cases this year. So now we're going to turn to you, Eileen, and get some legislative update from you. And again, attendees, there is a handout that Eileen sent out. You should have gotten from the bar office, and you can follow along. Take it away, Eileen. Thank you.
Okay, so first I'm seeing that some people are saying they might not have received the materials much in advance. And also I know sometimes clicking on the links that I inserted in my materials doesn't always work. So trying to do this from memory, but if you want to log on and try to open up one of the statutes to be able to follow along, you can type in mgaleg.maryland.gov. And if it works right, it should pull you to a screen that at the top has a box that you can type in the bill number that I'm going to discuss, or it's there for your reading pleasure when you're trying to fall asleep tonight. So I believe everybody knows that due to COVID, the General Assembly adjourned early. So even though in my role as legislative co-chair, I can say it felt like a very busy session with lots of movement in family law, including some very, a lot of movement even on talking about changing the grounds for divorce, like just conversations that haven't been had in the past while I've been serving. So only a few things made it through. And for anybody interested in trivia, apparently, according to the Baltimore Sun, the last time that there was an early adjournment was during the Civil War. So we have that piece of information. So the first bill that I'm going to discuss was House Bill 946, which is also Senate Bill 847. It's a child support guidelines. So it will change the family law article sections 12201, 12202, and 12204. A lot happened in this statute, a lot goes on, but it does not go into effect until October of 2021. So I'll go through it. So the main, well, one of, in my opinion, the main purpose, it included updated economic data and revised the guidelines in their entirety. And so in addition to incorporating current economic data, which the last data was 2008, there's now, so from the low, at the low end of the guidelines from 0 to 1,250, there's no discretion. There is a set amount of child support. And in coming up with the amounts at the lower end, there were adjustments made to the numbers for what's called the self-support reserve, with the idea that it was important that the obligors maintain a certain amount of income so that they could live above poverty line, with the idea that that would help them to be able to survive themselves and be more likely to pay the child support. So when you look at the new guidelines, there's going to be asterisks on some of the numbers, and those show you that this self-support reserve was taken into account when calculating those numbers. Then at the other end, the guidelines now cover up to $30,000 a month of income. So now at that end, there's less discretion. We don't have to really do the Bagley analysis anymore, and child support's not based on SASSy-Calc's interpretation of an extrapolation. It's actually based on the economic data. So those are some big pieces of that legislation. In addition to that, voluntary impoverishment and potential income are addressed in the statute. So there's now definitions for those terms that you kind of had to in the past maybe go into case law. They're now incorporated into the statute. And then also what's in the statute now is the analysis that you need to do when you believe that when there's a dispute as to whether or not somebody's voluntarily impoverished. So as opposed to looking at all the case law for it, there's very specific steps set forth in the statute with factors that the court needs to consider, and you need to present evidence on when those issues are at play. There is some additional language added about when the court can decline to establish a child support order. Some of it is when you live with a child that you're supposed to support. If you're unemployed and have no financial resources and incarcerated. So there's lots of factors that are times that the court can decline to do a child support order at all. And then the statute goes on to say that if any of those circumstances arise, that is a ground to modify child support. That's what's in that statute. Okay, as I told you, the effective date. Okay, then the next statute, it's House Bill 269 or Senate Bill 579, and this is called Child Support Shared Physical Custody. This one does become effective October of 2020. It will change Family Law Article Section 12201 and 12204. And SASSy-Calc has already been amended and can run these guidelines. So if you have SASSy-Calc, they will run the guidelines. But this is a revision to the concept of shared physical custody for child support purposes. So now, starting when one parent has 25% of the overnights, there starts to be a gradual decline in the child support calculation. And this is hopefully good news for family law and for children, that now custody disputes should focus really on the best interests of the child, because it's a gradual drop as opposed to that you need to get right to that 35% and have the significant decline in one step. So, one extra overnight doesn't dramatically change your child support obligation anymore. There's like more of a gradual step down. And the statute has a formula if you choose to do it manually. Then the next bill is House Bill 234 or Senate Bill 1006. This is another child support bill or statute that is about suspension of payments of arrears for incarcerated obligors. And it is is Family Law Article 12-104.1. So if you have an obligor who has been sentenced to a term of imprisonment of 180 consecutive calendar days or more, then there are no arrears accruing. It used to be 18 consecutive months. Then there are two statutes related to domestic violence. House Bill 250, Senate Bill 227 is peace orders and protective orders extensions. That becomes effective October 1, 2020. The statutes involved are Family Law Article 4-507 and Courts and Judicial Proceedings Article 3-1506. And what this legislation does is if you file for an extension of a protective order or peace order before it expires, and for some reason the hearing is not set before the expiration, the order that you're trying to extend will automatically extend until the hearing. So in practical effect, I guess that means we should be telling our clients that they should have their motion with them. Otherwise, I don't know how a police officer being called to enforce a protective order would know that you had filed it. Then the other domestic violence statute is it's House Bill 248, which it's entitled Protective Order, Relief Eligibility, Rape and Sexual Offenses. That modifies Courts and Judicial Proceedings Article 3-1503 and the Family Law Article 4-501. And what this does is, so it changes the definition of the person eligible for relief under both peace order and protective order. So, it essentially makes it so that if you are a victim of rape or sexual assault, that you now will qualify as a person who can receive relief under protective order, which was not the case before. That was under peace order. So under protective order, the language about sexual violations, it called it a sexual relationship. And what was happening was that it was being interpreted that you were not having a relationship with somebody who raped you or sexual assault or date rape. So there was inconsistent results. Some judges were giving protective orders in that circumstance. Some were not, and saying it was appropriate for peace order. The protective order has better relief. So now, so that there's no confusion, it's taken out of the peace orders and put into protective order. So now it's clear that any type of sexual assault, and there's definitions in there, or a rape, that you don't need to also establish that you had an ongoing relationship in order to qualify for the protective order. Because in both statutes before that, a rape that act counted as behavior that entitled you to the protection, but you were not considered a person eligible for the protective order by any judge who interpreted rape as not a relationship, which I guess it's not. Okay, so then the last one that passed related to family law is Senate Bill 102, which is vital records, birth certificates, change of name of child, which in its Health General Article 4-214, which essentially says you can change the name of a child on a birth certificate by affidavit if either both parents, if two are named, or one parent named on the birth certificate says it's their free and voluntary act and that they want to change the name. So then I also just put in, because there was a lot of interesting discussions about ground for divorce, and I do really think that had COVID not come our way, that this statute would have passed, because there was a lot of work done on the statute. It's House Bill 80, grounds for divorce. And in the past, I think any effort to really modify the grounds or to move forward on being able to divorce without a physical separation was slow moving in the General Assembly. And that changed a lot this year. So the compromise ultimately was that you could file, it's irreconcilable differences, and you can file for a limited divorce. You could have, had it passed, you would have been able to file for a limited divorce with no separation at all, just having to prove irreconcilable differences. And then the waiting period on desertion was going to go to 6 months. And if you had filed this limited divorce on the irreconcilable differences 6 months later, you could amend and ask for an absolute divorce. So if it had passed, the practical effect really would be that you could pretty much get an absolute divorce on whatever irreconcilable differences ends up being, but you wouldn't have had to be separated, because it's pretty hard to imagine that anyone would get through the court system within 6 months from filing for a limited divorce. But it didn't pass. I think it would have, and I guess I have no idea if there's going to be a session coming up or if divorce will make it to their hit list with everything else going on. But I thought it was interesting, and assuming there is activity in the General Assembly, we, with the Section Council, always want volunteers, and there may well be some more work on grounds for divorce. So anyone who wants to be involved with hearing what's going on and participating in testimony can email me. It's Eileen, ILENE, @lawhj.com. That's it.
Thank you, Eileen. We do have a question. And does House Bill 269, Senate Bill 579 impact the child support calculation for a case where a parent has 30% or more overnights, but less than 35% of the overnights?
Yes, it starts to change. Like, I think every number has changed. I have not run every number, but yes, like you should assume that it starts to change once you get to 25%, that it's all changed. So that the idea is that each one has a step down.
Was that the intent, was just to make it less of a cliff and more of a gradual?
Yes, it was completely about getting rid of the cliff effect, and that was how it was addressed, which was by moving it back.
And why is it that it's not going into, why the delayed enactment or effective date? Do you know?
And I don't know. I think I know, but I don't know that this is accurate, but I think it had to do with that the department was not able to change all their systems in on time. So it has to do with the support agencies not being able to do it. What I understand, but I don't know that that's accurate.
Excellent. Elena, I don't see any other questions. And all right, Eileen, thank you so much. Thank you for the preparation of the materials and for giving your contact information for anybody who wants to follow up on that. Thank you very much.
Actually, it looks like there is a question that popped up on the Q&A box. And this says, as to the child support statute is, in quotes, cases filed after October 1st, 2020 include modifications of existing orders.
So, are you talking about the one, so the shared custody or the child support guidelines? I mute myself.
It asked about the child support statute.
The one that goes into effect in 2021 that changes the child support guidelines, it doesn't speak to modification or not, but so the answer is if you file for a modification after it goes into effect, they would be applied, is my reading of the statute, but it doesn't speak to whether or not the enactment of these guidelines are a ground to modify.
Excellent. Thank you very, very much, Eileen. I appreciate it. And now we're going to turn our attention to the startup plan following COVID-19 emergency closure, and we're going to turn to our Honorable Ruth Ann Jacobowski.
Good afternoon, everyone. Thank you for inviting me to participate. I was planning on attending this anyway, and then Chris Nicholson asked me 2 days ago whether or not I would speak to where we are in our restart plan, and I agreed to do it. All of you should have received from the Bar Association, and it's on the website, there is a restart plan that is basic and explains the different phases, which you probably are all sick of hearing. But we are now officially in phase 2. I think there was confusion at the beginning because Judge Barbera issued her order that talked about phase 2, and it says in there, as I recall, there aren't going to be any hearings. However, it also said every jurisdiction can do their own thing. And that in fact has happened. So every jurisdiction has their own restart plan, and it varies across the state. All the administrative judges, just so you know, Judge Cox is not on this call because she's on another call. Her fingerprints are all over all of this, has worked tirelessly for the last 3 months. The administrative judges meet virtually 3 times a week to discuss what's going on across the state. And it does vary, but they try to get some uniformity in terms of what's happening. So what we're doing in Baltimore County, we are now in week 3, okay, of phase 2. So if you were to look at the dockets, the courthouse is not open to the public, but we are now having in-court hearings officially. There are dockets, there are regular dockets. They're limited though. The goal is to keep people out of the courthouse, frankly. Right now, we are having limited hearings. We are trying to keep the census down in the courthouse. If you've been in the courthouse, you know, if you come in for a hearing, you will get a temperature check. I get a temperature check every day when I come into the garage. You have to fill out a questionnaire. I have it on my phone. It's an app that you can download that says whether or not you're an employee, whether or not you've been in contact with anybody that's had COVID, whether or not you have any symptoms. If you answer, hopefully everybody's going to be honest. Okay, if you answer those questions, no, they're going to let you in. If you don't, they're not going to let you in the courthouse. The sheriff has the absolute right to keep you out. Okay, and that includes me too. And anybody, every employee, every judge, every magistrate has to be checked in that way. If you've been in the courthouse, there are sanitizers everywhere. We've reconfigured each of our individual courtrooms. I've been in court twice now. I wear a mask. When I'm in court, everybody has to wear a mask, okay, in court. I have a plexiglass shield clear in front of my bench, okay, no more bench conferences, okay. And there is a plexiglass divider in front of my court clerk. My court clerk and my law clerk are 6 feet apart. We have moved computers. The tables have only 1 chair. So you can choose to have your client behind you, and each courtroom has a maximum number of people that can be in there, and we have signs where people can sit. So we're really limited. I've only had 2 hearings. I've had 2 domestic violence hearings as chambers judge. So temporary protective orders, 1 unrepresented and 1 represented. So if you look at the dockets, we are conducting hearings. There's some family law emergency hearings, DVs, and other types of cases. We're having criminal dockets as well. Everything is staggered. And if you have a case that is set in between now and when we go into stage 3 and 4, if it's a day or less, your case will be heard. Okay, so if it's a day or less and it's set in June, July, and August, it'll be heard. If it's a day case, it's probably going to come in at 9 o'clock. If you're part of a docket where there is a I call it the miscellaneous family docket, you should be getting a notice. We're not having everybody come in at 9:30 anymore. We are staggering. So it's 9, 11, 1:30, and 3. So you should be getting new notices. So we are trying to limit the number of cases, and as we go into stage 3, things will increase, and then stage 4 and 5, things will start increasing. The assignment office, I can tell you, because I know I was speaking to everyone, I sort of put out feelers to all the different divisions, to assignment and mediation, just to see how things were going generally. So I do have some feedback to tell you how things are happening. The name of the day, the theme of the day is remote hearings, okay? So just as everybody's gotten used to Skype for business, which is the preferred statewide platform, the judiciary is moving to Zoom for the judiciary shortly. I don't have the exact date. We're supposed to get it put on our computers within I think this week, but it's not going to be live this week. We have to be trained. But remote hearings are now the preferred way to handle cases. And there's some types of hearings in the family division which are going to remain remote as we proceed through the phases. And I don't know that we're ever going back. I mean, I really think as difficult and as uncertain this pandemic has been, it has changed the way business is done, certainly for all of you in your practice. And it's really changing, and not necessarily for the worse, the way I think some things are conducted in the court system. I know a lot of family law attorneys have told me they really like a lot of the remote proceedings because it saves time. It's just easier to maneuver than having to come into the courthouse, wait for so long. And so we're going to be doing a lot more remote. So to give you an update of what we've been doing so far, phase 2 goes up until July 20th. We are doing remote hearings for scheduling conferences. That is going to continue for a while. We're doing 9 a day. Pre-pandemic, we were doing 13 a day, according to Abby. In 2 attorney cases with no access issues, they're doing those sooner than later. Notices are being mailed out. There's been a couple of complaints about not getting notices and not getting emails and finding out from their clients that their case was scheduled. So let me clarify what we're doing. During the pandemic, during the closure, really very few people were going into the courthouse, including, and right now we're really at 50%. So 50% of our staff is working remotely on any particular day, and times are staggered. So during the closure, the DCM staff, Abby particularly, and others were emailing. When they had email addresses, they were sending notices, they were sending statuses to lawyers. That is not happening now. MDEC is not an email on email notice. You cannot get from us an email notice. It is a pilot project. I think it's Anne Arundel County that has testing email. And it will be statewide eventually, where you're going to be getting orders by email, you're going to be getting notices by email, all of which makes sense. That is not now. So right now it's snail mail. Everything is going through the mail, okay? Now, what you need to understand about that, because I've gotten complaints about people not getting notices, is the mail is not going out every day, because people are not in the court every day that send the mail out. So there may be a delay. So be patient. Even when the mail goes out, it doesn't like go right. It's not like FedEx that they pick it up and they take it right to the, it's not that. It goes through the county mailroom and there is a delay. So if, for example, you get a notice, I just granted a reset today where a lawyer wrote to me and said they got a notice on the 17th for a hearing that was to occur on the 15th. That's a problem, okay? So he asked that the case be reset. It was on a default child support. Net, I absolutely said, I sent it down, said reset as soon as possible. So that's gonna happen. I ask you to be patient. You are not gonna get email notices. You will be getting mail notices, but there is some lag. There is a delay because not everybody's going in. More staff will be coming in. Somebody is always in the clerk's office, which is not open to the public yet and won't be till July 20th. But a lot of people are working remotely, but they're not mailing remotely. They only mail when it's in the courthouse. So there's a lag time. So you just have to bear with us on that. Okay, I think people got spoiled when they got email notices during our closure and thought that was what was going to happen. That is not the standard. That's not what we're doing. We don't have the ability to do that through MDEC. All right. So scheduling conferences are going to continue remotely. Some are being done by video. A lot of the pro se's, the magistrates tell me, are being done by phone. And they're able to narrow some issues. Some are settling, not all of them are, but we're moving along. Scheduling orders are getting done. Mediation is being done only by remote. And I asked Anna how it was going because she was very leery about remote mediation initially. And normally, I know some of you private practitioners have done remote mediation, private mediation, which I understand has been pretty successful. But she told me, which was I love to hear, that the stats on the remote mediation is 40% are settling, either fully or partially, which is great because on a normal in-person, she tells me it's 50%. So I am very pleased. We are going to continue with remote mediation at least through phase 4. We're going to reassess it. Come September, frankly, everything is subject to change. It really depends on what's going to happen. I mean, I don't have a crystal ball. You know, they're talking about another surge in the fall. That could shut things down again. We just don't know. But right now, we're proceeding through our stages until we're told otherwise by either the governor or Judge Barbera or Judge Cox. So we'll see what's happening. I do want, Anna did ask me to remind attorneys, you're going to be getting notices for these remote mediations that tell you and your client that they need to contact the Office of Family Mediation within 10 days in order to set up the remote mediation. So you're no longer going to be getting a specified date. You need to stay on top of your clients to do that. Because if they don't, it's going to get rescinded. They're going to miss mediation. Okay. So just stay on top of them. You got the notice. You need to contact. Be sure they contact to get their date. Status conferences are being heard. So if you had a settlement conference during closure with 2 lawyers on a case, you should have had a settlement conference. It was either with myself, Judge Kavanaugh, Judge King, or Judge Batista. We handled, I think, I haven't done the stats, but I think we handled over 300 settlement conferences. I know I did over 100, okay, during the closure. We're not doing those anymore except on an as-needed basis like I just did for Judge Burns. However, if you had a case where you were representing a client, but the other side was pro se, we were not having settlement conferences on those. Those are going to receive status conferences. You're going to be getting a notice from the Office of Family Mediation, and they will do what they can to get everybody together on a status call to see what's going on. If it can be resolved with Anna or her staff seeing where people are in the case, the magistrates are working with her to get it resolved, get orders done, and get testimony taken. You can put things on the record. It may not be that day, but that will happen. Okay. If it can't be resolved, she will sort of do the triage on it. So she will determine whether it should be set in for a settlement conference in front of a family law judge, or in front of one of the retired judges, I mean, or whether it should go for trial. So she's going to be doing triage. So if you get a notice for a remote status conference, settlement conference, it's because you represent somebody and the other side is pro se. Okay, so that's what's happening on that end. And that's going to be going on for a while, and she's going to clear out that backlog. Settlement court is open. It opened up July the 15th. We tried to encourage the judges to do it remotely, but Judge Martin, Howe, and Burns wanted to come in. They like to take the temperature of the room, literally and figuratively, I think. So they are coming in, but they also are doing some remotely. You heard Judge Martin is doing some remotely. And people have been asking me for remote mediation, remote settlement conferences, or to appear remotely. And I can tell you right now, I'm allowing it. I have not turned anybody down. If there's a reason your client can't appear, you can't appear. I've gotten reasons such as, you know, I live with my elderly mother, I can't be exposed. I have symptoms. I think I might have symptoms. My neighbor had, I'm letting them appear remotely. Okay. So if it's shown, if there's a reason, I am letting people appear remotely, and the settlement judges will be doing remote settlement conferences, even if some of the parties are appearing remotely. Family Support Services is doing I talked to Mary Stengel. They are working on their child access evaluations that have been ordered since the shutdown, are now being scheduled for November and October, which are pretty full right now. They're currently working on March, April, and May cases and trying to catch up. They were working throughout the shutdown. They were all working remotely. They obviously weren't doing home studies, but they were doing what they could to keep the things rolling, keep the cases rolling. Screenings are being done remotely at this time. And that's working, and we'll see, when we'll be able to bring people in for in-person screenings, but we're not doing that yet. Again, that's going to be reevaluated, probably stage 4 come September, October. All right. The visitation center is not open and is not probably going to be, again, we're reevaluating it, but we're not going to really reassess it until phase 4, which is September 1st. So if you have a client that is supposed to be getting access through the visitation center, that's closed until at least September, and we'll see where we are on that. Hearings are being heard and rescheduled. So I spoke to Chrissy in assignment, and I'm very pleased to report from her that all magistrate contested cases that were postponed during closure have been reset, okay? All defaults that were ripe during closure have been reset. Uncontested dockets have been scheduled out through September. Again, they're being staggered. Those are, again, remote is the platform that everyone is attempting to do, particularly for the uncontested. We did uncontested hearings throughout the closure. The magistrates did them, I did them, they were all done remotely. Just so everyone knows, I am no longer doing remote uncontesteds. My judicial assistant is still receiving emails, because I did do a docket once a week, asking to put it on my docket. I am not doing that anymore. So if you want to have your case heard and it's ripe, you need to put through file and serve a request to assignment that you want your case put on a docket, and it will get set in due course. So please don't write to me anymore. All right. They are hearing cases, as I said, judges and magistrates are currently hearing cases. If you look at the dockets that are a day or less, they're staggered. You should be receiving notices of a new time. And again, if there's some glitch in that and the mail is a problem, I've told you things, they're doing the best they can to get them out as fast as they can. If there's a problem, if you can't appear, I've been getting postponements for requests where cases are just being set in and people have conflicts, they have vacations, they have other cases. I'm postponing the case. We are now getting dockets. Judges, magistrates always had their dockets in advance, I think 2 weeks in advance. Judges, unless the case was specially assigned, did not. Because cases are being set out now in different manners, we are all getting our cases early. So I already have a case, I'm going into family July the 1st, and I already have my cases for the first 2 weeks of July. The purpose of us getting them early is we will be reaching out to the parties to determine if the case can be done remotely. Everything that can be done remotely, we are trying to do remotely. By Skype, by telephone, whatever we need to do, we are trying to do it remotely. The magistrates are doing the same. And if we feel we can't, then we can still bring the people in if we feel it's appropriate. But we will be reaching out. You'll have judges that will be reaching out to you to see if you can do the case remotely. If you're requesting a postponement, I had a couple this week where the case was already scheduled in front of a judge. I am deferring those requests to that judge and let that judge rule on it. All right. So the cases are already assigned up through the second week of July. The dockets are already out, which is new for us, so we can look at them and we are determining if we can do it remotely. If we can, then the JA for that particular judge will set up, or I will set up, whoever's doing it, a Skype invite at this point, which is how we're doing it, until we do Zoom, and then you will be having a remote hearing. Contempts are being reset if there's service. I, along with several law clerks, reviewed every single contempt that was filed or that was at issue or was on the books during COVID. If there was no service, I dismissed it. Okay. So I signed a lot of dismissals. I love dismissing things. I love closing cases. However, I've received some requests to reset the case because in fact, there was service, but nobody filed an affidavit of service. Okay, I'm resetting those. Once I have proof that there's been service, I will reset them. But we cleared out a lot of cases that were just stale. If there's service, they're going to be reset after September 1st. And the ones that are being filed now or since reopening, again, new contempts are being processed, and those will be set after September 1st, again, on staggered dockets, right? DVs are being heard every day. Both the chambers judges are hearing the temporary protective orders, the family law judges are hearing the DVs. Those are typically being done in person, although Judge Batista told me the other day he had a DV. The petitioner asked to participate remotely. I think it was the petitioner. And the other side said they had COVID or symptoms of COVID. The other side agreed and the hearing was done remotely. Contested cases, I encourage everyone, the rules are changing literally as we speak. There are new remote rules that I encourage everyone to read. I just printed them all out yesterday and read them in terms of cases after July 1st that can be done remotely. And it's in the rules, it's actually been passed. It went through very quickly. And cases even that are before July the 1st can still be considered for remote. And there's a process for remote hearings. If you are willing to agree to a contested remote hearing, you have a better shot of getting it done sooner than later. And we are strongly encouraging that, really in every case. You can have a contested case done remotely. So you know, Judge King did a contested, during our closure, emergency guardianship, 3-day contested case with exhibits that he was able to do. So it can be done. The way judges are doing it, I have not yet done one, but I would certainly entertain doing it, is you pre-file your exhibits through MDEC, and you have everybody available. It can be expert, he had expert witnesses available. There's ways it can be done that you can do a contested hearing remotely. So we're doing everything we can to move things along. All right, cases that are more than a day will not be heard that were previously set or set for the summer will not be heard. Okay, we're not hearing cases that are more than a day. Those will be reset after in phase 5, which is starting October the 4th. If your case is set in September, which is phase 4, and it's more than a day and it's already set in, we're going to let those proceed. Okay, so those won't be postponed. But if it's a case during this summer, June, July, or August, or if it was postponed because it was set during our closure, we're doing everything we can to prioritize cases and set them in before the end of the year. If you had a settlement conference with me, you know I've said to you that the chances are cases that are not settled at this period of time, normally you would get a trial date within 6 to 8 weeks, right? If you went to settlement court today, that's not happening. You're more likely to be getting trial dates in 2021. We're doing everything we can to prioritize cases, and things are going to change, and we're not resetting cases yet for October 5th because we don't want to keep postponing cases. We're trying to see what's going to happen with the virus and whether or not we're going to be able to continue through our plan. For the specially assigned cases, many judges have specially assigned family law cases that have had to be postponed. We've asked the judges not to set them now, have status conferences, see what's going on in the case, hope springs eternal, maybe the case settled, but not to reset it until August, because we literally in the family law area had hundreds of cases. I think it was 300 to 400 of cases that have to be reset. Which is a lot less than criminal, which I think was 2,000. So, I mean, the numbers are just daunting. So one thing I'm happy to report that Chrissy told me from assignment is everyone has been incredibly patient and nice, which I love to hear because patience is the magic word. That you need to be patient. I know everyone's anxious to get their cases heard. Judges are anxious to get the cases reset. We keep pulling back the judges saying, stop calling Patty, stop calling Chrissy. We can't reset your cases yet. we have to clear out the backlog first before we can start resetting these multi-day cases in the fall. So, and then there's certain criminal cases that take priority because of the rules. So it's a lot, and I think considering what's been happening, things are moving along. We're doing the best we can. I have scheduled some cases this summer, as many of you know, that tried to get through an emergency hearing. I granted very few emergency hearings, but I did grant a few. And if I didn't grant an emergency hearing and there was a denial of access, I have done what I can to get those cases in sooner than later on an expedited basis. So some of those will be heard this summer by family law judges. And we're trying to prioritize the older cases to come in before the newer cases. So it is a massive management job that we're trying to do that is a nightmare. But I think everybody's doing their part to try to keep things rolling. The moral of the story, and I've said this to everyone that I've had a settlement conference with, settle your case today. You can get a hearing tomorrow. I will get it on the record the next day, in front of a magistrate, in front of the judge. Maybe not tomorrow, but very quickly. We can get them in remotely. Nobody has to come to court. Everybody, we can swear people in. Everything's on the record. We can actually, some judges are working from home, some are going into court some days, we can actually do on the record from our home, call into a courtroom, it can be done. So if now's the time to settle your cases, if you're not having a lot of hearings, then now's the time to do that and try to get your case settled. And the motivation for your clients is if they want to be divorced in 2020, they need to settle their cases, because there's a very good chance they will not be divorced in 2020 if they don't settle their cases. So that's the good motivation, to get your cases settled. You settle it, you can get a hearing. Put everything on the record, get divorced. And that's been really good motivation. A lot of lawyers and a lot of clients have been motivated by that fact. I think that's all I've got. It's a lot.
It is a lot. Thank you very much, Judge. If we can just grab a couple seconds, I think you've already answered one of the questions, which is uncontested divorces filed last week are being set now in late September. Is there any hope of having these hearings set in sooner if they are done remotely? And you have answered yes.
I mean, all the uncontesteds are being done remotely. All of them are. So nobody's coming in, if at all possible. I just got a request today, some pro se litigants that want to do it sooner. I've asked assignment. They're scheduled for September. I don't know that it can be done sooner because our dockets are pretty full for the summer. So I'm checking on that. But if you have a case that is resolved, there'll be a way with either one of the family law judges or the magistrates that will be able to get it in if you have a case settled.
Okay. Another question is regarding a pro se litigant. If they do not have Wi-Fi capabilities to do a remote hearing, how is that being handled?
So most by phone, everybody has a phone. And I think everybody has a smartphone. I mean, except for Michael Lawler, who doesn't have a smartphone. But and I don't know if he's on the line, but I was just saying that he was able to participate in a video conference, even though the first time he was just using a phone. So most people have a smartphone, and I've done uncontested hearings with somebody on their phone, and you just download the Skype for Business app onto your phone and you can participate. If they just have a phone that doesn't have, not a smartphone, then they participate by phone. Okay.
Excellent. I think you've already answered this one, and that is, when can we start asking for trial dates in 2021 for trials longer than a day? And the answer is not yet.
Not yet. Not yet. Can't do it.
You had said they would be starting to reschedule those in October.
Starting in August and September, but please don't call Patty or Chrissy now. They are just completely overwhelmed. So I would just ask everyone to try to, I understand everybody wants to get back in and wants to get their cases done. And maybe these are cases that you don't think can be settled. And I get that. There are certain cases that need to be heard. But just you need to hold off right now and wait until, later in August or September is when cases that are more than a day will be reset. Okay? We just can't do it now.
One from the chat window. How are PL hearings being handled?
So I reviewed, as did the magistrates, we looked at all the PL hearings that were set during closure to see whether they need to be reset. I looked at all the ones that were in front of judges, and the magistrates looked at the ones that they had scheduled to determine whether they thought it needed to be reset. Frankly, I looked at every case. There weren't that many PL set in. None of them appeared to need to be reset because they were ready for trial. But when we sent out notices saying we're not resetting it, but if you think there's a reason to set it, let us know. If you want to have a PL hearing, you have to request it and you have to tell us why, particularly if it's ready for the merits. We're just trying not to clog the system with PLs.
And I think we have time for just one last question. We're over a little bit, but cases where the requests for default have been denied because of the tolling of the time from
Right.
March 16th on, how are those cases being handled?
So what we were doing during the closure is we weren't granting them because things weren't being processed. Those are supposed to be resubmitted. When I had chambers, I would say resubmit after court reopens. So those should be coming through chambers. If you have a case that was denied because of closure, then I would suggest that you haven't seen anything happen, then perhaps write through file and serve, say this case was denied because of closure. Can this be, there's still no answer been filed. Could you please submit this to a chambers judge? And it should go through now.
Excellent. All right.
Okay.
Judge, I cannot thank you enough, and I'm going to give a shout out to Chris Nicholson for inviting you in a couple of days ago, and you jumped right in, and I really appreciate it. And thank you, Chris.
No
as
problem.
well.
Happy to do it.
Eileen, Richard, thank you both so much as well. And Elena, I'm sorry we can't all hustle down to the CNR pub and toast your season, but this
Me
is the
too,
best.
but we'll do it soon enough, hopefully.
All right.
Cross.
Sounds good. Sounds good. That concludes our program. Thank you all so much for
Thank
being
you.
with us, and thank you for the panelists for putting in the effort.
Thank you all so much.
Take care.